The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome to our ongoing coverage in the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I'm Attorney Andrew Branca for Law of Self-Defense, providing guest commentary and analysis of this trial for Legal Insurrection. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, which can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife, Emily, is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Today saw the Chauvin court wrap up the testimony of martial arts and security quote-unquote expert Douglas Williams, a bystander witness to Floyd's in-custody death. It also saw the state proceed through 4 women I'll refer to as the minor witnesses because they were bystander witnesses who were under 18 years of age at the time of the incident. Finally, the state brought the firefighter bystander witness to the stand, with court recessing partway through the defense cross-examination of the firefighter. The most interesting event of the day was certainly during the testimony of the firefighter when Judge Cahill cleared the jury from the courtroom and scolded her, the firefighter, for being argumentative with the defense during cross, before sending her to bed with no dinner and telling her to come back to the courtroom for further cross-examination at 9:30 a.m. tomorrow. Kidding about the bed and dinner part. Before I dive into today's testimony, there were a couple of procedural questions that folks brought up today, and it's probably best to address them up front. One of these is the issue of a witness referring to notes while testifying. This occurred with witness Williams, the MMA/security/bro witness for the state. Early in today's cross-examination of Williams by the defense, Attorney Nelson noticed that Williams was holding some papers in his hand and kept looking at them and asked Williams about if they were notes. Curiously enough, Williams denied they were quote-unquote notes, but said he used them when he couldn't remember things. Sounds like notes to me, but whatever. Now, legally speaking, the problem with a witness holding notes is, first of all, that the witness is supposed to be testifying from memory. Notes can be used by a witness to refresh their recollection, but then must be put down in the testimony again given from that now refreshed memory. Even then, notes intended for such purposes must have been disclosed beforehand to the parties as part of the normal discovery process before the witness can make use of them on the stand. The parties are entitled to know what the notes actually say. These notes of Williams were obviously not shared with the defense beforehand, and I rather doubt even the prosecution knew Williams was bringing them. One fundamental concern about notes, of course, is that they could be written by anybody, somebody other than the witness, and handed to the witness with no actual personal knowledge of the events in question, who simply reads off the notes to the jury. There's no way to cross-examine or impeach a piece of paper, after all. So the way Williams was using his notes was inconsistent with proper court procedure, and it's procedure that actually does matter. Apparently, defense counsel didn't think it was enough of a problem to make a big stink over it, other than to ask Williams to limit himself to using the notes only to refresh his recollection. Those of you who enjoyed my coverage of the Zimmerman trial might remember that one of the state's medical examiners who testified at trial brought a whole bunch of notes with him, none of which had been disclosed to the defense. When defense counsel Don West asked to see them, as was his right, the doctor adamantly refused to share them, grabbing them close to his person and screeching that they were his notes, his personal property, that he prepared in his own spare time. It was reminiscent of Gollum and his precious ring. Absent the notes, it turned out this medical examiner had no real collection of any of the medical examination of Trayvon Martin, and so he proved another among a great many of the prosecution's witnesses in that case who had zero or even negative value for the state's case against George Zimmerman. In any case, that's the deal with what happened with witness Williams' notes today. The second procedural question had to do with the sequence of questioning of the witnesses. Currently, the state is presenting its case in chief, so these are all state witnesses so far. The state questions its witnesses first in what is called direct questioning. Then the defense gets to question that witness in what is called cross-examination, unless the defense has no questions, in which case that witness is done. After the defense has subject the witness to cross-examination, however, the prosecution may want to ask the witness additional questions to clarify things said on cross in what is referred to as not direct questioning, but redirect questioning or redirect examination. Then the defense also can ask the witness more questions, clarification, in what is called re-cross-examination. And that can continue. We may have redirect and re-cross, etc., all the way down. Importantly, however, each round of questioning is limited to the scope of the round in questioning that occurred immediately prior. That is, if the state's initial direct examination asked about issues A, B, and C, on cross-examination, the defense can ask about A, B, or C, but they cannot ask about issue D, which was not covered in direct. If they attempt to do so, they are exceeding the scope of direct, and that questioning outside of scope is not permitted. Let's imagine that on cross-examination, the defense permissibly asked about issue A and B, but doesn't ask about C. Then if the states want to engage in redirect, the state can only ask about what the defense just covered, issues A and B. Issue C is no longer on the table for redirect because it wasn't covered on cross. The natural result is that each round of questioning tends to get narrower and narrower as the prior round focuses on an increasingly smaller subset of the issues originally covered on direct. Hopefully that makes sense. It would be much easier to draw as a figure on a whiteboard than it is to describe using words, but there we are. Also, I had a question about asking leading questions, which the prosecution tended to do a great deal with a number of today's witnesses. A leading question is one which suggests the answer to the witness, and these are not permitted on direct questioning, meaning questioning of your own witnesses, although they are permitted on cross-examination. So if a prosecutor, say, wants to get their witness to share their personal knowledge of an event, and is particularly hoping, let's imagine, to have the witness testify that a green car came driving down the road, the prosecutor might properly ask, "And after you exited the store, did you observe anything noteworthy on the road outside?" If instead the prosecutor asks, "And after you exited the store, did you see a green car come driving down the road?" that would be a prohibited leading question on direct, because the question suggests the answer. Here, in this case today, the state seemed to ask a great many leading questions of its own witnesses, and I was asked why the judge permitted this to occur. Well, it's important to understand that it's not for the judge to call out such things as prohibited leading questions. It's up to opposing counsel to do that. If opposing counsel objects to a leading question, well, then they literally object. Objection, leading. And if the question was genuinely an improper leading question, the judge will uphold the objection and the question and any answer will be struck. If opposing counsel does not object, however, then there's nothing for the court to sustain and the leading question is allowed to pass. The judge isn't going to stop it on its own. The judge isn't going to stop it on his own. Now, why might opposing counsel allow this? Well, leading questions do allow questioning to proceed much more quickly, and it can make the entire court day very cumbersome to jump on every leading question. If the question and answer are unlikely to damage opposing counsel's arguments or would inevitably come in anyway after a long series of arduous but permissible non-leading questions, It's often just more efficient and more likely to stay within the trial judge's favor to let the leading question go forward. The result is that we sometimes see a great many leading questions, even though they are technically not permissible, or perhaps more accurately, even though they are technically objectionable. Finally, someone had asked me about writing about the jury instructions for the relevant criminal charges in this case. I do have those jury instructions. Unfortunately, they're not readily available on the internet, but given the nature of my work, I do have them. I'll probably hold off on writing about them until sometime this weekend when court is not in session. Okay, so with that out of the way, let's jump into today's testimony. First, the state's witness, Douglas Williams. This is the MMA security bro bystander. So court adjourned yesterday while state witness Donald Williams II was undergoing direct examination, so naturally things continue today with the state picking up where they left off. You'll recall that Douglas Williams is the MMA security expert, quote-unquote, who was the bystander witness of Floyd's arrest, who rather aggressively challenged the police on scene. As was the case with most of the state's witnesses today, the purpose of Williams' testimony seemed to be largely to share emotive observations of Floyd's in-custody death, albeit at least in Williams' case, there may have been a secondary motive in an attempt to leverage his purported martial arts and security expertise, quote-unquote. Much of Williams' direct testimony focused on Floyd's demeanor as he died. Things like he was in pain, his mouth was wide open, with drool and slob and dryness and eyes rolling back and trying to gasp for air and trying to be able to breathe and trying to move his face from side to side. Williams also made several comparisons between Floyd's demeanor and the death of the fish Williams had captured earlier in the day and kept in a plastic bag as they died, a rather strange story he'd first recounted yesterday. Another interesting theme among the state's witnesses today made it seem as if they'd all been carefully coached to make sure they denied that the crowd of angry bystanders had in any way acted in a manner that could be perceived as threatening by the officers. Yet throughout their testimony, they also couldn't help but recount actions of themselves or others that could easily be perceived as threatening. For example, Williams denied engaging in any threatening behavior, but then in an effort to make Officer Tao look bad, he recounted how Tao had put a hand on his chest to push Williams back to the sidewalk, which action was only required because Williams had stepped off the sidewalk and aggressively approached to within a foot or so of Tao. In a further effort to, I suppose, make himself look good and authoritative, Williams described how he was obliged to restrain other members of the bystander crowd to keep them from aggressively approaching the officers, which of course would suggest that the officers had good reason to believe the bystander crowd was inclined to close aggressively on them. Yet another common theme among the day's witnesses is that they were intent on engaging in mind reading of Floyd, of Chauvin, and others. With respect to Floyd, for example, Williams was prone to describe fear and pain as if he knew for a fact what Floyd was suffering, instead of limiting himself to his actual observations. It's fine to say that Floyd appeared to be suffering fear and pain and articulate why you had that perception, but not to definitively define Floyd's mental state. Similarly, Williams was prone to engage in mind reading of Chauvin, at one point describing Chauvin as definitively having no feeling, no remorse, no humanity. Naturally, the defense objected, and Cahill instructed the jury to disregard. But yet another common theme among the witnesses today was that even after the paramedics arrived and checked Floyd for a carotid pulse, Chauvin had still not removed his knee until Floyd was lifted up onto the gurney. As mentioned by a commenter in today's live coverage, this raises an interesting question. That is, if the paramedic was able to touch Floyd's carotid pulse without Chauvin having to move his knee, then clearly Chauvin's knee was not placed on Floyd's carotid artery and could not have been occluding carotid blood flow, even on that one side of the neck. I hadn't considered this issue, and it seems that perhaps Nelson had not either, or I would have expected him to drill down more on this point with the witnesses. Before he closed out direct examination of Williams, Prosecutor Frank made sure to dive into how Williams felt about the whole experience. That feeling was, of course, negative, as was the case with all the state's witnesses. How Williams or the other witnesses felt, however, has little to do with whether Chauvin violated any of the criminal statutes under which he has been charged. It's also notable that Williams would describe making his 911 call after the ambulance left with Floyd as, quote, calling the police on the police. This is a catchphrase used repeatedly by Prosecutor Blackwell during his opening statement. The message, of course, is that Chauvin's conduct as a police officer was purportedly so egregious that it was necessary to take the extraordinary step of calling the police on the police. The video of the direct examination of Williams, which follows, of course, on the start of his direct examination yesterday afternoon, is embedded in the text version of today's content. Now, after Prosecutor Frank was done with direct, defense counsel Nelson took over cross-examination of Williams for the first time. It was here that Nelson took notice of Williams' notes, and the exchange I've already described took place around the notes. Nelson did a good job exploring relevant use of force issues such as the disparity in weight between Floyd, some 230 pounds, and the police officers, the largest of whom Chauvin reportedly weighed, 140 pounds. Nelson did this by exploring the use of weight classes in wrestling and martial arts, which obviously divides competitors by weight differences of as little as 10 or 20 pounds, much less the nearly 100-pound difference between Floyd and Chauvin. Nelson also explored some of the more technical aspects of various chokeholds, including distinguishing air chokes and blood chokes, and you should put those in scare quotes, as well as attempting to get Williams to concede that an effective carotid blood choke requires constriction of the carotid arteries on both sides of the neck. Here it should be recalled that Chauvin's knee was applying pressure, obviously, to only one side of Floyd's neck, not both. Williams' responses here were largely incoherent and confusing and often self-contradictory. Frankly, he didn't really seem to know what he was talking about, and he insisted a carotid choke required constricting only one side of the neck. Obviously, questioning counsel cannot himself testify. Nelson can't testify. He can only ask questions, and he can't contradict outright a factual claim by a witness of this sort, absent immediately available impeachment evidence. But the defense has its own use of force expert coming up when they present their case in chief that it intends to call, and presumably that defense expert will be more articulate and better informed on these matters than is Mr. Williams. Williams did agree that a carotid choke results in loss of consciousness in a matter of seconds, which is obviously a vastly shorter time period than the 9 minutes or so in which Chauvin had his knee on Floyd's neck. Clearly, Chauvin could not have been applying a carotid choke for that 9-minute period, during nearly all of which Floyd was demonstrably conscious and talking and moving. Nelson also was able to undercut much of Williams' testimony, claiming that he'd merely been, quote-unquote, professional, while a bystander witness, by referring both to video footage of Williams at the scene as well as to the transcript of an interview Williams had done with police investigators. Nelson noted that Williams had called the officers such a man and bogus and such a tough man and an effing, P word, and an effing bum. Indeed, Nelson pointed out that Williams had called the officers a bum no less than 13 times. When asked if that was true, Williams became thoroughly hostile as a witness, repeatedly responding, "If that's what the video shows," until Judge Cahill finally had to order him to answer the defense questions. So the defense cross-examination of Williams is also embedded in today's content. On redirect by Prosecutor Frank, Williams described the police at the scene as being a human S show, to which Cahill naturally sustained a defense objection. Frank attempted to undercut some of Nelson's cross about weight classes and such by asking Williams whether in MMA fights or wrestling, one's opponent was handcuffed. Naturally, the answer is no, unless I suppose the opponent has just attempted to pass a $20 bill and then fought off lawful arrest. The redirect of Williams is also embedded in today's content, the video of that. Finally, the defense decided to recross-examine briefly by asking Williams if any time he had ever been choked out in martial arts, he'd been able to hold the conversation while that was happening. The prosecution made a silly objection based on hearsay. Obviously, Nelson was not asking for Williams to share specific statements made out of court for the purpose of their truth, so Judge Cahill overruled that silly objection. Williams simply answered that he hadn't previously been engaged in conversation when he was being subject to a carotid choke. One wonders how much conversation Williams ever engages in. In any case, the defense cross-examination of Williams is embedded in today's content, but we're still not done with Mr. Williams because the state decided to do a redirect. Here, the state asked Williams about whether in martial arts one is obliged to stop their chokehold if an opponent tapped out, and Williams laughingly said yes. It's not clear to me what the corollary to police use of force is here. Are the police supposed to release a restrained suspect if he taps out? But in any case, we were finally finished with Williams as a witness. So the state's redirect, very short video, also embedded in today's content. Let's move on now to state's witnesses, whom I call the four minor witnesses. I call them that. They were all four female minors, meaning they were under 18 years of age at the time they were bystander witnesses. And although two of the four have since achieved adulthood, are now 18 years old, Judge Cahill nevertheless allowed all four some special treatment, such as not having to give their names while on public broadcast. Accordingly, I simply refer to them as Minor 1, Minor 2, Minor 3, and Minor 4, respectively. Their names are public knowledge, so if you care to look it up in the public media, you can find it. I numbered them in the sequence in which they testified. Frankly, I felt these witnesses added very little of substance to the trial, although they did a great deal of emotive demonstration for the jury, each being emotionally distraught, sobbing, even crying on the witness stand. After all, the common theme went, they stood there and watched as the police killed George Floyd, right? Indeed, two of the witnesses were not even subject to any cross-examination by the defense at all. In the case of one, minor number 2, that was almost certainly a prudent strategic decision by the defense, as she was only 9 years old. As of the day of testimony, so more like 8 when this happened, she had little to add that the other bystander witnesses wouldn't separately testify to, and one wonders what level of cruelty it required for the state to have her subject to such traumatic recollection for not very good purpose. Another of the four minor witnesses, minor number 4, was also not subject to cross, likely because it would have served no substantive. Another of the four minor witnesses, minor number 4, was also not subject to cross, likely because it would have served no substantive purpose for the defense. Minor number 1, however, was subject to direct, cross, and redirect, and videos of all three of those are embedded in today's content. The witness's actual first name appears to have been Darnell or Darnelli. It was pronounced differently by other witnesses. And she was the older, at the time 17, now 18 years old, older cousin of the very young minor 2. Minor 1 and Minor 2 had traveled together to Cup Foods for snacks, and like the other bystanders, largely saw the same things occur. As noted, there were lots of emoting, lots of mind reading, lots of conclusory statements of fact, things like we all knew what was happening was wrong, objection sustained, jury will disregard, but little testimony of genuine substance, and at least that the video didn't already reveal on its face. Floyd was restrained by 3 officers, including Chauvin's knee, complained about breathing and being in pain, called for his mama, worsened physiologically, apparently died on the street, and Chauvin never, quote-unquote, let up to get up. Like every other bystander witness, none of the minor witnesses had a full understanding of what was occurring, even during the limited period they were watching Floyd's arrest, and none had any idea whatever of all of Floyd's conduct that led up to him being restrained on the street as he was by police. So first, I'll share the direct examination of witness minor number 1, Darnell or Darnelli. That's embedded in the text version of today's content. On cross-examination, I felt Nelson did a good job getting out of minor 1 what he could. Indeed, I felt that outside the purely emotive, minor 1 provided more substantive value to the defense than she did to the state. And of course, remember, she's a state's witness. As with Williams, Nelson was able to wheedle out of minor 1 testimony consistent with the bystander crowd being an arguably threatening mob to the police. She denied they were threatening, but then conceded conduct, such as repeatedly stepping off the sidewalk towards the police and becoming increasingly loud and angry, that could readily be perceived by the officers as threatening. Indeed, at one point, Chauvin and Tao each reached for their OC spray, conduct that minor 1 and other of the day's witnesses professed was utterly unnecessary, but which was certainly circumstantial evidence that the officers felt they might imminently need to defend themselves from physical assault. So the cross-examination of minor 1 embedded in today's content. Now, the conflict in testimony was between whether or not the bystander crowd was potentially dangerous or could reasonably be perceived as dangerous, although they explicitly denied they were dangerous or were behaving in a manner to be perceived as dangerous. This was highlighted again when Prosecutor Blackwell, who was conducting direct and minor 1, had asked minor one if she had seen a single thing that would indicate that Chauvin was frightened by the crowd. She said she had not. But her own testimony only moments earlier about Chauvin reaching for his OC spray belies that claim. So the redirect of minor one is embedded in today's content. So that brings us to minor two. As already mentioned, there wasn't much to minor two's testimony, as one would expect from a 9-year-old. So I won't spend much time on it here. Again, minor two was not even subject to cross-examination, so we only have the direct questioning by the state, again by Prosecutor Blackwell. That's embedded in today's content, text version of today's content. Minor number three was another female, now 18 years old, and in high school. She was subject to direct questioning by a female prosecutor, Eldridge, one we haven't seen in an active role yet in this trial until today. Minor three was one of a pair of girls who drove to the Cup Food to buy an auxiliary cable. The other of the two girls would testify immediately afterwards as minor four. Neither minor three nor four added much of substantive value to the trial, although there was, of course, a great deal more emoting. Interestingly, when the various videos are played during minor three's testimony, we can clearly hear MMA witness Williams telling Officer Tao, quote, I will kick the F out of you. I will kick the F out of you. You're a B word, bro. We can also clearly hear the firefighter Hansen, who will be the last witness of today and again in the morning, also calling Officer Tao a bitch. So the direct questioning of minor three is in the text version of today's content. On cross-examination, Nelson scored some real points, referring to a transcript of a phone interview minor three had with investigators shortly after the event. Nelson pointed out that she had told investigators that she had seen police restraining Floyd check his pulse multiple times before the ambulance got there. She also repeated this narrative of the police checking Floyd's pulse in discussion with the prosecution only days prior to her testimony today, discussion to which the defense apparently had discovery access. Minor three claimed she had no clear recollection of saying the officers checked Floyd's pulse multiple times, but had to concede the point when Nelson handed her the transcript of her interview. She also conceded that the bystander crowd around the officers was genuinely angry, which is an important circumstantial factor in the officers' reasonable perceptions of their practical options in that context. Indeed, it's worth noting again that not even the paramedics stayed on scene to treat Floyd, but rather did a load and scoot, immediately loaded Floyd into the ambulance and drove a safe distance away from the angry crowd before treating Floyd. So the cross-examination of minor three, again embedded in the text version of today's content. Prosecutor Eldridge did a very short redirect of minor three, hardly worth mentioning, so I won't, but I do embed the video of the redirect of minor three in the text version of today's content. State's witness minor four was essentially an emotional wreck throughout direct questioning by Prosecutor Eldridge, with sobbing and weeping on the witness stand. The state got nothing out of her they hadn't already gotten from the other minor witnesses, and the defense did not even bother cross-examining her. I did, of course, embed the direct questioning of minor four in the text version of today's content. And that brings us to the prize witness of the day, state's witness firefighter Genevieve Hansen. So, Genevieve Hansen appeared on the witness stand in her full dress uniform, presenting quite a different sight than she had as a bystander witness, clad in sweatpants on the sidewalk. Before even direct questioning of Hansen began, the prosecution submitted to the court some video evidence of the scene, Hansen's video, and audio evidence of a 911 call by Hansen afterwards that was quote-unquote published or played in court before Hansen took the stand. I've embedded that publishing of that video and 911 call in the text version of today's content. Once direct examination began, this time led by Prosecutor Frank, much time was spent polishing Hansen's training and experience, albeit as of today, she'd only been a firefighter for about 2 years, and so for barely 1 year at the time of Floyd's arrest. Most of Hansen's testimony was little different than that of the minor witnesses. I just recounted a lot of emoting and mind reading, but little of substantive value. Like them, she had only a limited view of what was happening and had no knowledge of what had led to Floyd being restrained on the street in the first place. When asked what she would have done had she been permitted to quote-unquote treat Floyd, most of what she recited was actually taken. When asked what she would have done had she been permitted to treat Floyd, most of what she recited was action actually taken by the officers, like calling 911 and checking Floyd's pulse. Other proposed actions would have been effective only if Floyd's cause of death was actually Chauvin's knee, which of course is a key issue in dispute and appears to be an unlikely cause of death on the available evidence. Other possible actions suggested by Hansen were of a sort that neither the officers on scene nor Hansen in sweatpants was in a position to provide, like use of a breath bag or of Narcan for drug overdose. In short, if Floyd required that care, he'd need to wait for the paramedics already called for by the officers. It is notable that at no time did Hansen make any reference to Floyd's ingestion of a 3-fold fatal dose of meth fentanyl speedball, ingested to prevent discovery of the illicit drugs by police, a far more likely cause of death than Chauvin's knee. Like Williams, Hansen had also called 911, called the police on the police, to report her conclusion that she had just seen police kill a man, but then had hung up before completing her report to a police sergeant. She had no good reason for hanging up other than getting distracted by events with other bystanders and late arriving fire department personnel, co-workers of hers, at the scene. It seemed that Hansen did an okay job as a state witness on direct, and of course I've embedded the video of her direct questioning in the text version of today's content. Things went less well for Hansen on cross-examination by Nelson, however, largely because she proved rather outrageously hostile and uncooperative, to the point where a very irate Judge Cahill would eventually clear the jury from the courtroom and chastise her directly before sending her home for the day and adjourning court. More on that in a moment. On cross-examination, Nelson touched on the substantial training required to be a firefighter and rhetorically placed Hansen in a hypothetical situation similar to that of the officers. Would it be difficult for her to follow her training and do her job putting out a fire if she's being shouted at by a threatening mob, he asked. Hansen insisted it would not negatively impact her ability to do her job at all, but the protestations came across as entirely insincere. Nelson also explored whether she had ever before sought to interfere with police securing a scene for called medical personnel, and Hansen had to concede she had not. An interesting exchange occurred when Hansen insisted to Nelson that a main reason for her concern was that she believed firefighter EMTs could have been on scene prior to Floyd's death, and that the delay in medical personnel suggested something had gone wrong. Nelson pointed out that the police merely call for medical, period, and it's the dispatcher who determines whether paramedics or firefighter EMTs get sent. This whole exchange opened an entirely new narrative for the defense, in that the fault of providing timely care to Floyd might have been that not of the officers who called for care promptly, but of the other components of the city's emergency response system. Hansen gradually became increasingly hostile and uncooperative. When asked if she remembered making particular statements to investigators, she denied knowledge or recollection. When offered a transcript to refresh her recollection, she refused to look at it. When compelled to look at it, she conceded she'd made the statement, but then attempted to provide a lengthy, complex, legally irrelevant explanation for why she made the statement she'd initially denied remembering having made. As noted, eventually Judge Cahill had enough of Hansen, cleared the jury, chastised Hansen directly. Even while he was chastising her, she continued to be argumentative, this time directly with Judge Cahill. As you might expect, that went poorly for her. That chastisement closed out the court for the day with a very irate Judge Cahill, so we'll use it to close out today's wrap-up post as well. I have the cross-examination of Hansen, which will continue tomorrow morning, but today's video of that cross-examination is embedded in the text version of today's content. And if you only want to see Hansen being chastised, it's short and worth a watch. I've separately cut out that short video clip so you can watch it independently, also embedded in today's content. Okay, folks, that's all I have for you today. I'll be back tomorrow morning with live coverage of the Chauvin trial once again. Until then, I'm Attorney Andrew Branca for Law of Self Defense, guest commenting for Legal Insurrection. Stay safe.